smell or trash pole revealing stalk is not going to be contemplated as anything but illegal.
Was contraband.
Now listen. So what does that mean? So now,
after December 6th.
Now, when they did the MMFLA, how could they say that the class of people, in that opinion, the limited class of, is just that? Because now we've got owners, operators, transporters, grow licensors, consultants. I mean, you've got all this other behavior of people that our law now protects. And now we have, of course, MRTMA, which has defined the use of it in quantities to be carried around, and most importantly, 12 plants to be grown. So if you can grow 12 plants in your house.
Or outdoors, as long as it can't be seen from a public place with the unaided eye, and as long as it's secured.
Well, okay, good point. And a good point of contention. I had a case about this in the venue that...
But I think if that's violation in itself would only be $100.
The outdoor grow in MRTMA is substantially different than the requirements of the MMMA.
Correct, and it's, I think, actually a much more liberal requirement under MRTMA that if you're caught in violation of that, it's only a $100 civil infraction, but you lose your plants.
Fine, you're right. And in the violation,
which is not good.
We don't know what the violation of the MMA is going to, falls into the MRTMA. We would argue and believe and be dealt with in whatever remedies exist there, as opposed to the default to the public health code as it has been. But the question I was asking was the definition of a outdoor grow, as it was amended in 2013.
Yeah.
Is, I agree with you, is the penalties for MRTMA are less, but the compliance requirements for MRTMA are greater.
No.
Yes, they are.
No, for the MMA, their compliance requirements are greater because it can't be seen from any neighborhood structure. Whereas for MRTMA, the only requirement is it can't be seen from a road or public place with the unaided eye.
Other way around.
No, if that's what MRTMA is, but the MMA says that you can grow it outdoors as long as it can't be seen from a neighborhood, from, say, the house next door.
So is its presence still probable cause?
So I think it's tougher to grow under MRTMA. I mean, under the MMA, at least in your average suburban neighborhood.
What justifies a knock on the door? Knocking.
I don't think
so much has happened.
Just remember the golden rule. Only break one law at a time.
There you go. I got it.
Good advice.
Marijuana plants grown outdoors are considered to be in an enclosed locked facility if they are not visible to the unaided eye from an adjacent property when viewed by an individual at ground level or from a permanent structure and are grown within a stationary structure that is enclosed on all sides except for the base by chain link fence, wooden slats, or similar material that prevents access by the general public and that is anchored, attached, or fixed to the ground, located on land that is owned, leased, rented, blah, 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 blah. So
that's much more restrictive.
I think the key here is the following: that the marijuana plants grown to be considered in a immunity situation when they are not visible to the unaided eye from an adjacent property when viewed by an individual ground level. So what it means is that from an aerial view, that's not a violation.
Right.
Okay. And if someone's a neighbor right next door, even if they're on top of each other, you got slatted fence that can't see into it. You don't need a top as long as the plants aren't going above it, right? They're looking at it from their bathroom window and upstairs, looking down into it is not a violation. Now,
that I disagree. I would need to get the law in front of me.
I have it in front of me. I just read it.
It must have been. That's not how I remember it.
It's not how Alan remembers it.
You're mixing it up, I'm telling you.
But anyway,
from the
despite that,
listen,
from adjacent property, read that again.
When viewed by an individual at ground level or from a permanent structure.
Right. So from the adjacent property, a permanent structure, they could be up in that bathroom. At ground level or at a permanent structure. So I disagree. I think that the
from a permanent structure.
saying would allow growing under facts that would not.
The ground level I can't look past. It can't be both. It can't be at ground level as the place by which your visual unaided sight is to be evaluated.
Or from the permanent structure, which wouldn't be at ground level because the structure's on the ground. Yeah. I think we need to acknowledge the fact we're over the time limit of the show and get in some final closing.
Oh,
I think
Alan.
the show's been off.
No.
Are we still running? We can keep running. It's
You
not
go
my
late,
clock.
you go long.
We go as long as we
You go
need to
as long as it
go.
takes.
Okay, we can run over.
We don't just stop.
I feel
I'll
honored.
show you why.
You know that some municipalities have abandoned their role.
We
in
don't
this,
just stop, Alan.
completely. They say that they're not.
Maybe that's what Alan
Fires
Pfizer does.
What's that bag right there? Is that oregano?
Yeah.
This,
We're making
this
pizza, Alan.
24/7 law enforcement can come onto your facility at any time is unconstitutional.
But it's not the local cops that are doing it.
No.
Lots of
But
stuff.
it allows law enforcement is what I believe the word said.
You want to talk unconstitutional, Jeff? Southfield passed a caregiver ordinance about 5 years ago.
Oh, Alan.
It's
It was longer than
unconstitutional.
5 years
I got a
ago.
6 years ago.
conversation with the city attorney, and he suggested that he's not taking any.
In the microphone, counselor. We cannot hear
Shyler,
you.
please.
It's very difficult.
I got in discussion with some city attorney, and he basically said just that he has no role in the regulation of licensees and has no actual authority to even go in them. It's left to the administrative government and the regulation of Michigan State Police.
I was talking specifically about the head.
Which city attorney?
Yeah.
Yeah.
But
Yeah,
that's the thing. That's how he's approaching it from his city, and it's a real city.
Yeah, okay.
So
It's not a
we'll
fake
see how long
city.
that lasts.
Yeah.
Important. It's important differentiation. Yeah.
Because I think most of them are blowing a gasket over Mertma. Most of them are encouraging
Mertma.
their city council to pass a resolution opting out of commercial medical facilities, also opting out of MFLA facilities.
Fumla.
And the cops treat me like this.
Right. There's just still that reefer madness mentality.
Wet and dry.
It's the way it is. You know, you have wet and dry counties for alcohol. You're going to have wet and dry areas for cannabis.
Yep. And on that note, I think it's time we wrap it up. Alan.
There you go.
All right.
This is what you can't do. You're allowed to cultivate, or you can't
I
do.
don't
Cultivate
know.
marijuana. This is MIRMA. If the plant, let me read it from the start. This act does not authorize cultivating marijuana plants if the plants are visible from a public place,
Oh,
Right.
shit.
without the use of binocular,
Not good.
aircraft, or other optical aids, or outside of an enclosed area equipped with locks or other functional security locks
Right.
that restricts access to the area.
That's much more liberal. Think about a suburban
Any public
neighborhood.
place.
Right. A suburban neighborhood, a backyard would qualify under those facts. Your neighbors could see it, but it's not public.
From any public place.
But you can't see the backyard from a public place.
From any place that somebody may have been in public.
Unless you have a corner lot, you can't see the backyard of most suburban neighborhoods.
So the fenced in would certainly end up being a clear indication.
Well, yeah, if you have a fenced-in corner lot, that would work too. But the point is, yeah, that you could grow legally much easier under MIRTMA, and I expect we're going to have a lot of badasses doing it this
is what I'm saying.
summer.
Let's think from a public place above ground level is what could be violative here versus medical marijuana plants that are in a public place seen, but you're above ground level would not be violative. That's what I'm sticking with.
Well, yeah, I think that this could be an area where we'll see a lot of increase in arrests this fall. That people have predicted that arrests would increase with the passage of this law, just like arrests increased with the passage of the MMA in 2008. And I really don't know that we have an answer right now. Time will tell. But I suggest that this liberalized outdoor growing may lead to one area with increased arrests because people may have difficulty counting to 12.
It is tough.
I think it's going to be a lot.
I think the bigger problem is that how is law enforcement going to know whether or not there's more than 3.3% of THC when they've already declared that they're incompetent?
That's what the Michigan State Police Crime Lab will do.
And furthermore, has already indicated that they do not test for quantities of THC.
That'll be
I
good.
rest my case.
Over civil infraction.
Drop mic.
Jeff. It'll be
It's
good.
over. They cannot distinguish either. And the real question is, does a presumption exist?
There's a lot of potential money for somebody who can sell a device to the police that can accurately measure.
They
that
have the
stuff.
machine. They just have to retrain the dummies. Do you understand?
You know, if they can make a breathalyzer for THC, the police
they don't
would
have
buy it.
listen, the
It's all
drones
junk science.
Yeah.
that show up and repeat
Oh, it's an Abbott Lab.
the propaganda that
ju-
is fed into their wires that are connected to the back of their brain that program these drone responses. It's too difficult to reprogram. I'm just telling you.
It's junk science to believe that a certain THC level is associated with impaired driving. But the police would still like to be able to measure that THC level because we do have laws that say that if you're impaired by THC, you're violating the motor vehicle code. And then
100%.
yeah. And depending on how you look at it,
No, it's not. It's completely
it may either
legal.
be a zero tolerance approach, or may they have to show you're impaired. And courts are still, by the way, taking both approaches as of this week. With the zero tolerance approach being done,
Schuyler
Yeah.
believes in a per se limit. He just wants it
yeah.
clean. I believe in proving
Especially being
impairment.
for
Right, Schuyler?
pulling the zero tolerance approach on a 19-year-old, saying that MRTA doesn't protect a 19-year-old for driving
That's not true.
with cannabis. Now, this is what the court said this week. Was not my client.
I'm saying I don't agree with the court.
This week, a court said that MRTA does not protect a 19-year-old for driving with cannabis.
It does.
And, he wasn't entitled to the $100 civil infraction.
He is. He's entitled. I think it's actually a $200 infraction.
I-
So
I-
He was
I
under
hope he can
21?
afford that.
Yeah, 19.
under 21?
Yeah, he's under 21, but he's
19
over
first
18.
And so they wanted to get him under the public health code.
No, they can't do that.
He's not my client. I
It
just read about
specifically
it.
prescribes what happens when you're under 21 but over 18.
I agree, but I...
Specifically
No, it was a
prescribes.
trial court thing.
Yeah.
What judge and where?
I don't know.
You don't know.
His attorney was Darrow.
Where the hell were you?
Yeah, he had a Darrow attorney. I don't remember. I know, but that's where I read
Alan,
the case.
Are you sure this happened? Where was this?
I believe it was someplace in Macomb County.
Oh no, that's not good.
Rejection vague.
Yeah.
Your TMA basically says that all.
There's no such thing as a rejection of vagueness. All right. So let's go on. Jim, I think you got a final thought. What's his final thoughts? We usually get chance.
I guess my final thoughts are. I heard we might be on the road again next week. Is that true? It was just a rumor I heard.
Michael,
What are you saying?
He doesn't want to answer.
are we going to be on the road next week?
Possibly.
I heard a rumor
Yeah, I
that
think
we
we're gonna
may
have to
be
celebrate
hitting the
some
road.
stuff.
Schuyler will be there. Schuyler, don't drive
Road trip.
through the wrong city.
Road
next
trip.
time,
I like
all
that
right?
idea.
I'll hook you up with
Animal
with
House. You remember that
GPS.
scene?
Yeah, it's good.
Good.
And then, of course,
Well, I'll go with my car.
as far as my concluding final thoughts would be, fuck Bill Schuette.
Yeah, final.
Schuyler feels uncomfortable laughing about that. He can't say that.
Yeah, that's because
Can't say
he's
it.
our token
Cannot say it.
Republican. Congrats,
No.
Schuyler.
He literally feels
Congrats.
that his First Amendment rights don't extend to that. I think that may be beyond that. Say it. Go ahead. Schuyler, your final thoughts.
I think that we're gonna
Into the microphone, Schuyler.
Growers are gonna experience reverse Santa Claus from the cops. Just your plants are gonna be gone, and they're gonna leave you a ticket.
Oh.
It's up to you,
It's better than going to prison, right?
right? I mean, that's what they're allowed to do under the RTMA. Take
Yeah.
your plans and give you a ticket.
Right.
That's right.
So just
They take your marijuana. I'm sorry, they take your marijuana. You
Right, so they
forfeit
take
your
your
marijuana,
marijuana,
which is the worst part of
give
it.
you a ticket.
$100 ticket, yeah.